My name is Jonathan Ackerman, and I want to briefly introduce myself. I'm a tax attorney with a Master of Laws in Taxation from Georgetown University Law Center. I've been practicing for just over 25 years, and I've been working with a number of different exempt organizations, both public and private charities and other exempt organizations. And what I do is I help them in their creation and in their governance, in tax qualification issues and tax compliance issues. As a part of the process of adopting these basic policies, these fundamental root type policies, I think it's important to educate your board and your officers on their fiduciary duties. To take a step back, generally a fiduciary is any person acting for the benefit of another. But when you think about it in the context of the tax-exempt organizations, it's really acting on behalf of others because charities function for the public good. So the fiduciary has certain responsibilities, and I break them into two categories in the nonprofit arena. One is for tax issues and tax compliance, and secondly is for operational issues, such as, are you meeting your charitable purpose? Are you acting consistently with your governance structure? And of course, are you complying with applicable laws? Generally, a fiduciary is more specifically defined as special confidence reposed in one who in equity and good conscience is bound to act in good faith and with due regard to the interests of the other person. Now, we're going to talk much more specifically about standards of conduct, but that's a good general way to view a fiduciary duty. So who are the fiduciaries for a nonprofit? Well, basically, it's the directors and officers, and in certain circumstances, may be the key employees. Another corollary of what a fiduciary needs to do from a general conceptual perspective is they need to have adequate information, okay? So, for instance, reviewing budgets, the financials. If there's a strategic plan, they review that. And of course, prior minutes. And then another key is to have an opportunity to ask questions. So you gotta be informed if you're gonna sit on a board. And then a question comes up all the time, well, if I'm a board member, but I'm not a lawyer and I'm not an investment person, so does a board breach a duty because they delegate authority to somebody else? And the answer is no, and it comes down to reasonable reliance. The way I like to look at it is rely but verify. And that could apply to investment managers or attorneys or CPAs and so forth. The last basic concept I wanted to go over with you is an idea called the business judgment rule. Now, so long as a fiduciary performs the duties in accordance with the specified standard of care, the fiduciary will not have liability based upon an alleged failure to discharge those duties. The idea is directors have to have the ability to exercise broad discretion on behalf of the corporation without being subject to hindsight assessments of their decisions by the courts. Now, there are a couple of exceptions like self-dealing transactions, and we'll get into the conflict of interest policy, and of course tortious conduct, personal injury and actions of that nature.